the indigenous people of Biafra, lady, the 21-year-old that has been, detained by the security operatives, to, unveil the indigenous people of Biafran's hideout and also the Eastern Security hideout, said that the 21-year-old Gloria Okolie drags the Inspector General of Police IGP Malami AGF orders to cough. Yes, she has dragged them to court. And what have you? The 21-year-old Glory Okolie, who has been in detention since June 17 over her alleged relationship with members of the proscribed indigenous people of Biafra. It has been said that the militant wing, which is the Eastern Security Network ESN, has dragged the Inspector General of Police Usman Baba to court. Well, let me read again for your hearing to understand more. The 21-year-old Glory Okolie, who has been in detention since June 17 over alleged relationship in 2021 with members of the proscribed indigenous people of Biafra, IPOB, and its militant wing, the Eastern Security Network, has dragged the IGP, Inspector General of Police, Usman Baba, to court. Aside from the IGP and the Nigerian Police Force, others that were cited as defendants in the suit Ms. Okolie filed before a High Court of the Federation, Federal Capital Territory, which is the FCT Abuja rather, the commander of IGP's Intelligence Response Team, Tunji Disu, and the Attorney General of the Federation, AGF, and Minister of Justice, Mr. Abubakar Malami, Senior Advocate of Nigeria, SAN. The applicant in a fundamental, rights enforcement suit is demanding an immediate and unconditional release from detention, as well as an order mandating the respondents to pay 1 billion naira as general and punitive cost for infringing on her rights. In a supporting affidavit that was attached to the suit, the court was told that the applicant was on June 13 found to be missing after she went to run an errand in Imo State and never returned home. That from the 17th June 2021, the family members started making all frantic search of the first applicant in hospitals, churches, and mosques, all to no avail. That the family members in search of the first applicant actually approached the Owerri Command of Nigerian Police Force, who charged the uncle of the first applicant the sum of 50,000 naira to track wide telephone tracking the last known address of the first applicant. That the phone tracking above showed that the first applicant was detained by the respondent IGP IRT officers at their Owerri Tiger Base unit of the respondent, and when the uncle approached this office, the respondent's Owerri Tiger Base unit denied ever arresting the first applicant, nor was she in their custody. That not until end of June 2021 that is certain Izuchukwu Okeke, having just been released from the respondent's unit Owerri Tiger Base cell, informed the family and uncle of the first applicant that the first applicant was in custody of respondents at Owerri unit cell, and in the said cell she was cooking for the IGP IRT, the response team police officers, washing clothes for them, and sometimes that therein, the respondents' Owerri Command Unit officers occasionally take turns to abuse the applicant sexually. Oh my God! That afterward, the respondent officers then demanded monetary commitment from the uncle of the first applicant for the release on bail of the first applicant, wherein the first applicant's uncle thereafter, in cash and POS bank transactions, actually advanced to the respondent's IGP IRT officers in Owerri Tiger Base unit different financial sums in these regards. For you that would not understand the meaning of the first applicant, yes, I know you understand, but for those that still need expansion, the first applicant, which simply means the so-called girl, the proscribed girl that they said is working for the ESN. So that's the first applicant. So she was detained in the cell and afterwards she's been abused sexually, taking rounds, over the girl, and she was also cooking, washing for them. Well, to continue, says copies of these aforementioned POS transactions are marked as Accenture's hearing. The court was told that the 21-year-old student was subsequently, transferred to Abuja despite spirited efforts by her parents to secure her release. Specifically, the applicant is seeking a declaration of this honorable court that the act of the respondent in detaining the first applicant from the 13th June 2021 till date without an order of any court date, and without any order of the court permitting same, is a violation of the first applicant's right to fair hearing and personal liberty as enshrined in Articles 1, 3, 4, 5, 6, and 7 of the African Charter on Human and People's Rights Ratification and Enforcement, Act Chapter A9 LFN 2004. The court document reads, a declaration of this honorable court that the act of the respondent in detaining the first applicant from the 13th June 2021 and beyond 71 days till date without an order of any court permitting same is a violation of the first applicant's right to fair hearing and personal liberty as enshrined in Articles 1, 3, 4, 5, 6, and 7 of the African Charter on Human and People's Rights Ratification and Enforcement, Act Chapter A9 LFN 2004. A declaration that the beating, slapping, torturing, physical assault, and verbal vulgar abuse of the applicant by the first respondent and the respondent's IGP IRT officers without the applicant committing any crime known to law whatsoever. It is illegal to detain that girl. It is unconstitutional and amounts to a violation of the first applicant's right to fair hearing and personal liberty as enshrined in Article 1, 3, 4, 5, 6, and 7 of the African Charter on Human and People's Rights Ratification and Enforcement, Act Chapter A9 LFN 2004. You see that this girl has been molested. This girl has been, tampered with, under the law that says, violation of human rights. It is said that a declaration that the usage of the applicant by the respondent IGP IRT officers by sexually assaulting the first applicant, usage of the first applicant to wash the respondent officer's clothes, and usage of the applicant to cook for the respondent IGP IRT officers, even when the applicant was in the illegal custody of the respondent, and without the applicant committing any crime. Why will she be arrested? Another of these honorable court restraining the respondent to disease from engaging in or toward violent and irrational conduct against the first applicant. That is why the family and family of the girl has deemed it fit to charge Abubakar Malami, the Attorney General of the Federation, and also the Inspector General of Police, charged them 1 billion naira for violating our fundamental human rights. So automatically, as it is, the court has charged Malami. Can you see the impunity and the so-called daring and temerity these people have, towards the citizens of Nigeria? The headline which says IPOB, the detained 21-year-old Gloria Okolie drags IGP Malami orders to court. So, so they go bring right.